Good morning. It's great to see you all here. Welcome on behalf of the law school, on behalf of the Coleman Burke Center for Environmental Law. Welcome to our conference on the 50th anniversary of the Clean Water Act, the past, present, and future of our nation's primary federal law concerning surface water quality. It's in some respects appropriate to have this conference here. Some of you have heard me on this ad nauseum before, but our city has an interesting place in the history of water quality regulation and the history of environmental policy. It's not always a well understood story, although it's more understood now, I think, than it used to be, because events here certainly helped catalyze the political movement for a federal statute like the Clean Water Act of 1972. As you probably all know ad nauseum, this picture appeared in a 1969 issue of Time magazine, a story that reported on an incident in June 1969 when debris and oil and chemicals on the surface of the Cuyahoga River caught fire. Time thought that was sensational, a river burning, and published this picture in which it also talked about the sad state of Lake Erie and the environmental problems that were faced not just by Cleveland, but by many cities and parts of the country. But as you all probably know, there was a fire in June of 1969. This is not a picture of it. It's a picture that is, to this day, still often reproduced in articles and tweets and web postings and the like, talking about that fire, but it's not a picture of the 1969 fire. As best we can tell, this is the closest we have to a picture of that fire. It burned somewhat intensely, but was out within 30 minutes. It caused some damage to a railroad trestle. Was a minor story of only a few column inches in the local press. Where'd the picture come from? There was a really bad fire in 1952. A fire that, had it not been on a weekend, would not have only caused millions of dollars in damage, but almost certainly would have resulted in the loss of life had there been people working on the docks and the like that day. And if we go back in history, there are in fact lots of fires on the Cuyahoga River, samples of press clippings from Cleveland's history about the risks that fire posed in the early 20th century. We can also, though, find accounts of fires and this is important for those of us who are from Cleveland and get harassed by our friends in other cities, that there were fires in Columbus, and there were fires in Detroit, and there were fires in Philadelphia, and there were fires in Baltimore, and there were fires, in fact, on industrial rivers throughout the country. By 1969, we'd kind of forgotten about that because that was a problem that had largely been addressed, not because of what we would today think of necessarily as environmental reasons. It was because fires destroy things and risk lives, and even the companies that were the source of those problems realized that liability, loss of employees, loss of valuable things was something that they should do something about. By 1969, though, we were concerned about other things. We weren't just concerned about property damage. We were concerned about the ecological health of our waterways. We were concerned about the effects that the accumulation of contaminants, the failure to control and treat sewage and the like had on us, had on the broader environment. And there's no question that the picture was a vivid image, and we know how important images are in politics to help catalyze political movement. And so if one goes back and looks at the history of the Clean Water Act, one certainly sees references to the 1969 fire here, even though it, again, was not the type of problem we were now focused on. It was a symbol of things that we cared about. And so it's appropriate that we're here in Cleveland to talk about the Clean Water Act and its first 50 years. It's also timely. I would in some way, I'd almost like to say I planned this, but I didn't. But it's very timely to have a discussion about the Clean Water Act this week. Because the Supreme Court is certainly interested, it seems, in the Clean Water Act and could have an effect on some of the things we talk about today. It was already the case that the Sacketts, a couple some of you may be familiar with, who have been to the Supreme Court before in their tussle with Clean Water Act regulators with the EPA and the Army Corps of Engineers are getting a second trip to the Supreme Court to try and bring clarity, narrow, constrain, pick the adjective you like, the scope of the Clean Water Act's regulatory jurisdiction. And the way the court has styled the question presented in this case leaves the field open. We could get a narrow technical opinion about how circuit courts are supposed to apply the Marx rule when they're concerned, or we could get, here's in fact what the Clean Water Act means, period, for now and all time, or at least until Congress revisits it. And if that weren't enough, just a couple days ago, we had an order off the shadow docket, or the remote motions docket, or the emergency docket, or whatever we're supposed to call it, staying a lower court decision that had invalidated a Trump administration regulation, narrowing the ability of states to subject federal permits to, or narrowing the ability of states to raise their concerns about the environmental effects of certain permits under Section 401 of the Clean Water Act, and I know we'll talk about that today as well. The litigation in this case is continuing in the lower courts, and will presumably reach the court at some point, but the fact that 5 justices thought that a stay needed to be entered now certainly is an indication that 5 justices at least have some concerns about Section 401 and the way it has been understood and implemented and enforced for, and now I'm going to embarrassingly forget what the year of that decision was, but for about the last 30 years or so. So there's potentially change on the horizon, lots to talk about in terms of not just the past of the Clean Water Act, the present of the Clean Water Act, and given that we still have water quality problems that we are concerned about, the future of the Clean Water Act. A few other quick words. Things like programs like this would not be possible, certainly were not for all of you, the speakers and moderators that are here today, students of the law review that are helping with the logistical stuff, our AUV folks, Eric and Patty who do the work supporting the centers, the law school, which has been incredibly supportive of programs like this. And I should also say to Coley Burke, who 3 years ago gave the law school $10 million to create an environmental center and to create programs like this, to allow discussions like this. Coley's no longer with us, but I think he'd be proud to see that we're carrying on investigating and examining issues that mattered to him and trying to put those resources to good use for the students, for the study of environmental law, for the broader community, and we certainly appreciate that he made things like this possible. That's it for now, so I will turn it over to our first panel. I'll ask our moderator and first panelists to come up to the bench. And again, thank you all for being here. I think we're gonna have an exciting day, and I'll look forward to the conversation.
While we're getting organized, let me take a quick minute to ask you all to read the bios of the speakers, since they're all distinguished and eminent professors and scholars. So I will just very quickly note, and hopefully you can see who is who, but we have here Nina Mendelson, professor of law at University of Michigan Law School. Please look at all of the publications, books, etc. for everyone. Also, Professor Robert Adler from the University of Utah College of Law, and Professor William Buzbee from Georgetown. And really, truly, we want to get to what they're going to be talking about, so
you all hear me? Okay, all right, wonderful. Thank you so much for the invitation to participate in this great day. And as Professor Adler mentioned, it's especially fitting that Case Western is hosting because of our proximity to the Cuyahoga River and, of course, so the Clean Water Act is one of our great public interest statutes enacted during that public interest era that also gave us the Clean Air Act amendments of 1970, of course, the Endangered Species Act, the Occupational Safety and Health Act. Okay, thank you. All right, that's the kind of feedback I'm grateful for. Okay, so the Clean Water Act is one of our great public interest statutes, right? This came from an era that also gave us the Clean Air Act amendments of 1970, the Endangered Species Act, the Occupational Safety and Health Act, the National Environmental Policy Act. I would even include the Voting Rights Act and the Motor Vehicle Safety Act of 1966. And of course, the Clean Water Act gave us ambitious water quality goals. So let's see if I can get the slides to work. What's the best way to get the slides to work?
The space bar or the down button?
Excellent. Thank you. So the enacted purpose, of course, of the Clean Water Act is well known. It's ambitious to restore the integrity of the nation's waters, including ending pollutants discharged into the waters by 1985 and achieving the protection of fish, shellfish, and wildlife even earlier by 1983. And of course, as you all know, the core jurisdictional term in the Clean Water Act is waters of the United States, the definition of the term navigable waters. And as you all know, and this is the focus of my remarks this morning, the Supreme Court has been changing its approach to interpreting that term, that core jurisdictional term, and that change is linked importantly to the rise of textualism as the dominant mode of interpreting statutes. So the point I want to make this morning is that textualism, as applied in the particular setting of the Clean Water Act, gives us some important lessons about that interpretive method. And in particular, textualism has some significant and negative impacts on Congress, and in particular on a Congress that is trying to enact public interest statutes. So these are some of the core claims for textualism. The theory here is the text is the law, and the idea is that judges are most faithful to Congress when they take that position, that they focus on the text constituting the law, rather than say the law's spirit or the law's goals. On this theory, judges are most faithful to Congress when they take this approach. But of course, the text is not always clear. It can be ambiguous. It can be fuzzy. Categories can have fuzzy boundaries. And so textualism has its preferred interpretive methods for resolving those difficulties. Rather than looking at legislative history, textualists try to extract the most meaning from text by using things like dictionaries and canons or even corpus linguistics. The theory is this makes interpretation, better approximate what Congress is trying to communicate with its text, and it's more constrained on judges. It's less easy for judges to manipulate the statute and come out with a result that they prefer. So with respect to Congress in particular, the theory is this is more faithful, and Congress knows how statutes will be interpreted and can adjust accordingly. So we can learn some important lessons about textualism from looking at how the court has handled this key issue under the Clean Water Act, waters of the United States. And again, of course, that phrase affects the major operative portions of the statute. They don't have any application if a water body is not within waters of the United States. So this is Riverside versus Bayview Homes. This is actually this is one of the earliest Supreme Court cases on waters of the United States. This is actually a photo of Lake St. Clair, Michigan, my home state, which is the focus of this case. This is not, as far as I know, the waters involved in the case, but it is similar. And the court in this case unanimously decided wetlands adjacent to Lake St. Clair, whether or not they had a surface water connection to the lake, qualified as waters of the United States. The court stated, its ruling affirming the inclusion of these marshes was consistent with the Act's approach, which was a kind of a broad, systemic view of protecting water quality, including, and the court recognized, the Act took an ecosystem approach and was focused on controlling discharges at the source. So the court said it was reasonable for the Army Corps of Engineers which was the acting agency in the case, to take a rule-based approach and generally to include basement wetlands because, in general, wetlands were likely to have a broader impact on the quality of water across the entire ecosystem. And I know there will be many people speaking to the function of wetlands today. But the point is, the court was willing to take an expansive approach in response to the Army Corps of Engineers. But later cases shifted to textualism, and the effect was to downgrade both these kind of overarching goals and deference to the views of agencies tasked with implementing the statute, whether that's EPA or the Army Corps of Engineers. So this is Solid Waste Agency of Northern Cook County versus Army Corps. This is a 2001 opinion where we start to see the influence of textualism. I want you to know that I spent a lot of time looking for this slide. This actually is the water body in Solid Waste Agency of Northern Cook County. I had to get it out of municipal archives. You can see that despite its origin as a sand and gravel excavation site, it has become, by the time of the decision, a fairly sizable water body that is now pretty integrated with the neighboring wooded area. And as you know, the agency took the position that this is important habitat for migratory birds. So the majority rejected this. Justice Rehnquist, for 5 justices, said, look, this is an abandoned sand and gravel pit that the municipalities in the case want to fill with their garbage. But we need some meaning for the word navigable in the statute. And at the bottom of the slide, this is a quote from the opinion. Justice Rehnquist said, look, this is a far cry from the term navigable waters. Now, certainly, you can see from the picture, you can put a boat in this water body, right? It's more navigable in the boating sense than the marshes that the court found appropriate to include in Riverside, Bayview, but the court rejected it as just too distant from, some kind of core meaning of navigable, and, thus began a pattern of deploying canons to reinforce the court's textual approach. So the court references the avoidance canon, but the one I particularly want to mention is the federalism canon. One of the interpretive moves in this case is the court says, look, we don't want to entrench upon state prerogatives over land and water use. The federalism canon had not been devised by the courts until the 1970s and 1980s. It was devised in connection with state criminal jurisdiction. This was the first case in which the court said, we're going to expand this canon to put a thumb on the scale in favor of state autonomy over land use planning. So it's a newly devised textual canon that gets used in the Swank case to bolster the court's textual approach. But it's really Rapinos versus the United States in 2006 where we see assentive textualist methods in this area. Professor Adler alluded to the Sackett case being back on the Supreme Court's docket. I think it's very likely we'll see some of the moves in particular in the Scalia plurality in the Rapinos case, return in the Sackett case. So I'm going to focus on the Scalia plurality since that's where I see the most traction being gained by use of textualism. So this case involves lots and lots of acres of wetlands, again in Michigan, with a surface connection to tributaries, to navigable waters. The slide on the upper left is an overhead view of the wetlands and in proximity to the tributaries. So you can see that in the red circle, it's a fairly large area and it's proximate to tributaries that drain to the Pine and Saginaw rivers in Michigan. The right-hand side is the drain that Rapinos built to drain all those wetlands. So that's actually what was done to eliminate the water in those areas. The picture on the lower part of it is the berm in the related case, Carole in the Rapinos case. So the question here is this covered under the Clean Water Act? And here we see classic textual moves. Justice Scalia's focus is the term the waters in the statute. So he says, that's not just water in general, it's the waters. That has a connotation of permanent standing, flowing bodies of water. And a classic textualist tool is to invoke the dictionary. But the dictionary picks is the 1954 Webster's Dictionary. This doesn't sound like a big deal, but of course that predates the Act by decades. And in fact, it's an old edition. Webster's has come out with a new edition. The third edition has come out in 1961, more proximate to the Act. It's not the one that the justices choose to use. So this dictionary is really about conforming to Scalia's intuition of the term's meaning. The dictionary mentions streams, oceans, rivers, lakes, and bodies of water, and so forth. And so he says the inference we draw is it doesn't apply to intermittent flows, ephemeral flows, what he calls wet meadows. They just seem too much like land, just as Scalia says. Okay. Again, this is an example of a term having a core meaning, but also fuzzy meanings at the boundaries. And of course, it's hard to draw a boundary between, if you will, the core of a water body and its edges. Scalia's textual approach allows him to focus just on the core. Okay, so this is sort of a, kind of a greatest hits of waters of the United States cases. What can we learn from this? So, application of textualism in the context of the Clean Water Act affirms several critiques of textualism that I and others have talked about elsewhere. So, one is the choice of the question you're going to answer. Are you going to look at navigable waters, or are you going to look at waters of the United States? The choice to use your own ideas about what one would naturally think a phrase would mean. You wouldn't say, according to Justice Scalia, that the waters includes waters that flow only sometimes, or a distant wetland. Picking dictionaries without explanation. Why pick a 1954 dictionary for a 1972 statute, especially when there's another edition out there, and the development of new interpretive methods. So the use of an expanded federalism canon in the Swank case is one example of this. At a broader level, in 1972, if you look at the Supreme Court decisions at the time Congress enacted the Clean Water Act, intentionalism was the dominant strain in the courts, with a heavy reliance on legislative history. There was barely a hint of dictionaries or canons in use in 1972. It's fair to say Congress could not have anticipated these developments or drafted around them. Okay. So these are probably familiar critiques of textualism to some of you. What I want to add here is that textualism has a great potential to distort the public process, and in particular to undercut public interest legislation like the Clean Water Act. So textualism emphasizes judicial intuition about word meaning and old dictionaries over something that we know about these statutes. Justice Breyer has pointed out, Justice Scalia acknowledged this as well at times. Congress's choice to legislate broadly, to use a phrase like waters of the United States, rather than listing oceans, rivers, marshes, and like, communicates an expectation that the statute would last and would be applied over time in a flexible way to respond to modern issues and understandings that Congress knew it could not envision. So one of the things that's clearly driving the waters of the United States cases is a worry about checking agency power. And I worry that is one thing that we will see in the Sackler case, and perhaps people will raise this over the course of the day. But the impact on Congress is also a significant one. To see this, we just really need to recognize that the statutes that empower agencies to respond are regulatory statutes. If they work, regulated entities have to bear the full cost of their activities rather than externalizing the costs to the environment, to water resources, and to society as a whole. So wetlands cases are about regulating builders and industry who want to fill those wetlands. The insights of the public choice theory of legislation tell us how difficult it already is to enact public interest statutes. Because in these statutes, benefits are diffusely spread among lots of people, across society as a whole, even wildlife, and costs are concentrated. Concentrated, well-funded interests are already overrepresented in the legislative process. That's well documented. They're also overrepresented in the agency process as data rulemaking confirms. So it's very easy to halt legislation because of the large number of procedural hurdles. You know, a well-funded, well-organized interest group is usually well able to slow down legislation that might target costs upon it. But this kind of textualism, which responds narrowly and without regard for purpose to broad statutory language, effectively also rewards regulated entities. So when wetlands are held not to be covered, those who want to construct buildings or factories can benefit. If you will, they get a few extra exceptions, a few extra deals in the language without having to go through the deliberative process of legislation. So we're going to protect the nation's water resources, if you will, some of those that home builders might want to use. This is hard for Congress to correct because it means organizing specifically in a way that will impose burdens on a well-organized, well-funded set of interest groups. And overall, it's a lot easier for Congress to correct a statutory overreach, if you will, if an agency goes too far and is too protective of society, or a court goes too far and takes too expansive a view of a statute. It's a lot easier for Congress to correct that and create an exception to broad operative language. It's a lot more difficult for Congress to deliberate to correct a court decision that creates an exception that narrows a statute's coverage and that benefits regulated entities. In short, this textualism in the name of checking agency power also undercuts legislative deliberation and reinforces distortions of the legislative process. So where might this take us? As we continue our debates on the right way to interpret statutes, the right way to interpret the Clean Water Act in particular, and with SACIT round 2 looming on the horizon, we need to take account of the burdens that textualist imposes on the legislative process. So rather than being faithful to Congress, it undercuts the deliberative process in the ways that I've been talking about. The use of legislative history statements, which was the problem that textualism responded to, I think was rightly criticized at the time. The questions that we should be asking now are whether the choices that textualism opens up are any more constraining on judges or any more faithful to Congress than a kind of more nuanced approach to purpose or intent to resolve ambiguities in statutes or kind of fuzzy boundaries. So, as we celebrate the Clean Water Act's 50th anniversary, statutory interpretation ought to support and not distort, a public regarding process such as the one that led to the Clean Water Act. I think that should mean less of this sort of textualism. All right, I look forward to the comments of other panelists and to the discussion. Thank you.
Good morning, and when my slides, while my slides are coming up, let me add my thanks to my brother, Professor Adler. Actually, he's not my brother, but my real brother is Jonathan Adler as well, so I kind of come here. So it really is remarkable to me that a half century into implementation of the Clean Water Act, we still don't know what one of its most foundational terms means. Right? That's pretty remarkable in terms of what Professor Mendelson has talked about. And I want to thank her as well because we didn't coordinate at all, but her talk actually flows perfectly into mine. So here's my basic thesis. A couple of years ago, a student co-author and I wrote an article in the context of the County of Maui case about whether or not a discharge through groundwater into a navigable water is jurisdictional water, in which we argued that the courts have atomized the Clean Water Act. That is to say, they construe the act by reference to individual terms in isolation from the whole text and structure of the statute and all of the statutory terms. So the WOTUS debate, the Waters of the United States, debate, I actually hate that acronym, I'll try not to use it again, has focused narrowly on the meaning of two terms, navigable waters and waters of the United States. I'll try to demonstrate how that's been done in isolation from other key statutory terms and provisions. Second, there are really multiple lines of cases on overlapping issues. So what is a water of the United States? what is an addition of a pollutant to waters of the United States, and that includes the issue of whether or not a transfer of pollutants from one water body to another is a pollutant. And I'm trying to read my slides up there. Oh, and can the Maui issue, can an addition occur through another medium rather than directly to a water body? So any construction of these terms, navigable waters, waters of the United States, has to answer all of those questions in a consistent way. And that's not something that the courts or actually the agencies have done as well. Now, in 15 minutes, I only have time for the first part of that analysis, so I'll do the first part. And you can read the second part in the written analysis of setting up the sequel here. So Professor Mendelson did a great job of talking about this, so I'm just going to summarize the existing interpretive approaches that the Supreme Court has taken. Justice White in Riverside said, we need to defer to agency scientific expertise on complex scientific issues of where the land ends and the water body begins. Chief Justice Rehnquist in Swank said we need to pay better attention to the statutory text and also this principle of constitutional avoidance, not getting too close to a constitutional line, which, as I'll talk about later, I think is a somewhat spurious argument in the context of regulating water. Justice Scalia in Rapanos said, just read the dictionary. Justice Kennedy, in his, what is to most courts the controlling opinion, came up with a judicially derived scientific text, which is something that I think is perverse for courts to do, and I'll critique that later. My proposal after my analysis kind of surprised me, which is to actually blend the Rehnquist and the White approaches, which is to say we do need to pay attention to statutory texts. Of course, we have to do that, but we also need to defer to agency expertise where it's appropriate. My caveat is that there are anomalies in the Clean Water Act that are really hard to reconcile. And the reality is that the statute was written over a number of amendments over a number of years by different members of Congress and different congressional staff. And there are flaws. I mean, there are clearly flaws that are hard to reconcile. So we need to do the best we can with the statute, but recognize that. So this is the Orwellian reality of the Clean Water Act. These are most of the terms that Congress has used to define various water bodies. And there are a lot of them. So we need to try to find a way to reconcile them. Now, not all of them are definitional, right? And I'll talk about that in a minute. And many of them are there for particular statutory purposes. So, for example, the term estuary is there for purposes of the National Estuary Program. But I divided it. I tried to categorize it. The nation's waters is the overriding term. I'll talk about why in just a minute. I divided these into water, waters, and water bodies. So water includes freshwater and surface water and groundwater and so forth. Water bodies lists all sorts of different types of water bodies for different purposes in the statute. And then the term waters, you can divide into navigable waters, waters of the United States. Interestingly, navigable waters of the United States, which is a seemingly circular analysis, which I think we can actually recognize in legal and historical context. So I couldn't do this for all of them, but I tried to sort out what I think are the core jurisdictional terms. And those are the nation's waters, waters, groundwater, which has, I think, surprising importance, and then waters, navigable waters, waters of the United States, and navigable waters of the United States. And what I did was, with the help of one of our law librarians, Suzanne Darius, did a statutory word search. It was somewhat laborious and identified every place in the statute where each of these core terms are used and in what context. And it came up with, I thought, some surprising insights. So question number one is, what are the nation's waters? Notably, this core term, it defines the statutory objective is used a single time in the entire statute, but it's used in the opening provision of the statute. So you can interpret this language one of two ways. You can interpret the nation in the nation's waters narrowly to mean the federal government, the national government. So perhaps waters that are subject to the navigational servitude or subject to Commerce Clause control. I think that's an implausibly narrow interpretation of that, because then there would be no way to distinguish between the nation's waters and waters of the United States. And when Congress uses different terms, another canon of statutory construction is that we have to assume different meanings. I think a more reasonable interpretation is that the nation means the entire country, which is the geographic boundaries of the United States, and means all waters within the geographic reaches of the United States, augmented by the fact that it's a term used only once at the beginning of the statute. Okay, so then what are waters? And we find this interesting distinction in the statute between water and waters. And one that has perplexed me for many years is that opening objective provision says restore and maintain the chemical, physical, and biological integrity of the nation's waters, which makes sense if you view waters as water bodies or aquatic ecosystems. The definition of pollution is the man-made and man-induced alteration of the chemical, physical, and biological integrity of water. That may be a drafting mistake. I don't know if that was an intentional distinction, but if you think about it, it makes no sense whatsoever to talk about the biotic integrity of water, right? It makes sense in the context of the biotic integrity of aquatic ecosystems. So if we look more closely, and I don't have the time to talk about all these in detail, so I'll categorize them. If you look more closely at the places in the statute where Congress used water and the places in which they use waters, it begins to make some sense and to explain some of these difficult jurisdictional issues. So water quality-based effluent limitations in section 302A apply to a specific portion of the navigable waters. All the provisions in the statute that require states and EPA and the defaulted states to identify impaired waters, so 303D, 304L, 319, talk about water bodies as components of aquatic ecosystems. So one implication is that the unitary waters theory that EPA and the states have proffered, I think doesn't make any sense structurally in the context of the Act. Water clearly can't mean all water. It can't mean water in this cup. Congress didn't intend to regulate that in the Clean Water Act, but if you look at the provisions in which Congress talks about protecting recreation in and on the water and enhancing the quality of water, the logical distinction is that that means water within water bodies, that is, water within aquatic ecosystems. So, what about this curious distinction between waters of the United States and navigable waters of the United States? And the circularity is that Congress first defines navigable waters as meaning waters of the United States, and then it talks about the navigable waters of the United States. And the only way to really make sense of that is to understand that before the Clean Water Act was written, there are actually 4 separate definitions of navigability for purposes of constitutional law. And the 2 key ones are the navigable in fact test for historically navigable waters under the Daniel Ball test, and the broader test for navigability that the Supreme Court articulated in U.S. versus Appalachian Electric Power, saying any water bodies, the use and effect on which might affect a navigable water or jurisdiction. So the places in the Clean Water Act where Congress used the term the navigable waters of the United States are typically those waters over which the Corps of Engineers regulated or dredged for purposes of traditional navigation. So it makes sense in that context. There's this very curious provision that came up, 33 U.S.C. 1293A. which is not actually part of the 1972 Clean Water Act, but it's codified along with it. And it was adopted 2 years earlier by Congress. And actually a year before Congress actually wrote the Clean Water Act in 1971, when the committee hearings and markup was going on. And it refers to a dredge spoil program for all navigable waters and other waters of the United States, which clearly means that Congress, a year before it wrote the Clean Water Act, understood this distinction between traditional navigable and fact water bodies and the broader notion of waters of the United States, supports the notion that waters of the United States is in fact broader, and it reflects that existing case law. So what about groundwater? How is groundwater relevant? So I think the debate about groundwater has been mischaracterized very often as whether or not the Clean Water Act applies to groundwater. Well, of course it applies to groundwater because Congress invoked the term groundwater in many places in the statute. The more precise legal question is for what purposes. So it's possible for water bodies to be covered by the Act for some regulatory purposes, but not others. Section 208 is the original planning and non-point source provision. It's somewhat defunct as a matter of implementation, but it's alive and well in the statute. Congress did not repeal it when it wrote Section 319. Section 304A, which governs EPA promulgation of water quality criteria guidance for the states, talks about groundwater. So EPA's water quality criteria are supposed to govern groundwater as well as surface water. And this is a somewhat complicated analysis. I don't have time for it, but if you parse the language of 303C, the provision governing state water quality standards or EPA authority to write water quality standards if the states don't do so properly, it appears that states have full authority to write groundwater quality standards under the Clean Water Act, which makes sense given that the water quality guidance address groundwater, but that EPA, the federal government, does not have that authority. So groundwater is part of the nation's waters, but not necessarily part of waters of the United States for purposes of some subsidiary goals and implementing mechanisms. Okay, so this is the set of provisions that I think are almost most telling. It's provisions where Congress combined multiple terms of scope in the same provision. So Section 102 refers to comprehensive programs for preventing, reducing, or eliminating the pollution of navigable waters and groundwaters. And then there are other provisions that do the same thing, navigable waters and groundwater in the contiguous zone and oceans and so forth. It makes no sense for Congress to have called for comprehensive programs of water pollution control for groundwater, but only a subset of navigable waters, right? Why would it have done that? It clearly envisioned the much broader sense of all surface waters and all groundwaters, but then perhaps parse which provisions of the statute apply where. So here's a summary of my synthesis. My students, especially in civil procedure, will tell you that I love Venn diagrams, so I'm going to use Venn diagrams. This is a somewhat simplified view of this because, number one, my PowerPoint Venn diagram skills are lacking to get much further, but in part due to time. So the nation's waters is the umbrella term. It's the broadest term of scope in the statute. Everything else should fit within it. The term navigable waters, as defined by Congress somewhat incongruously in the Clean Water Act as waters of the United States, Congress intended the Commerce Clause, meaning the U.S. v. Appalachian Electric Power, meaning of navigable waters, and not the narrower navigable, in fact, test from the Daniel Ball, because Congress used a separate term, a narrower term, the navigable waters of the United States. And again, if you actually look at the provisions in which Congress tended to use that, which I'll do in the written version of the article, are water bodies that are appropriate for the navigable, in fact, test. So now the trick is to fit all those other types of water bodies into that. I don't have time to do all of it. I'll do it for groundwater because I think groundwater is most telling. So option number one is that groundwater is part of the waters in the United States for purposes of Commerce Clause, are fully subject to Clean Water Act regulation. This is the argument that Mike Blum makes in an article that he and a student published a couple of years ago. I would like it to be that way from an environmental perspective, protection perspective, but I don't think that's right, because I think that would leave little, if anything, in that blue zone of what's within the nation's waters, but not the navigable waters or waters in the United States. There are all of the exceptions in EPA's regulations. It was clarified in the Obama Clean Water Act, Waters of the United States regulation. So there are some waters that might fit there. But I don't think this is a particularly correct interpretation. The other extreme is that groundwater is part of the nation's waters, but not at all part of the navigable waters of the United States. But with the caveat that we get from the County of Maui case, which is that if there is a discharge of pollutants through the groundwater into an otherwise navigable water, that is subject to regulation under the permitting provisions in section 402 and 404. I think that's a plausible interpretation. I actually think that this is probably the most accurate interpretation if you look at the Act in context and its purposes, and that is to say that groundwaters are part of the waters of the United States where they are clearly hydrologically connected to an adjacent surface water. And I know that's a fine line. It's a hydrogeological fine line because all groundwater, unless it's a completely segmented aquifer, is eventually going to be connected to waters of the United States. It's something we deal with in water law all the time, as well as in Clean Water Act law. But why is adjacent groundwater, which is immediately contiguous to a surface water, any different from a non-navigable tributary of a navigable water for purposes of what the waters of the United States are? Right, so I think some groundwater, I think this is a reasonable interpretation, fits within the waters of the United States. Others remain subject to that County of Maui test. And I could do this, of course, for all the different categories of waters that we've talked about, and I'll endeavor to do that in the broader analysis. So with that, here's the implications for, and my critique of the different Supreme Court approaches that Professor Mendelson talked about. And I kind of surprised myself here in who I agreed with and didn't agree with for what purposes. But we need to come to resolution here, right? So we need to get away from the complete extremes and to try to come up with a resolution that makes sense in the context of the statute and works for everyone. So the White-Stevens deference to the agency scientific expertise approach. Given this huge proliferation of undefined terms, there's no way around deference to the expert scientific agencies to whom Congress delegated the authority to interpret and implement the statute. But we can't avoid the statutory text and context altogether. I don't read Justice White or Justice Stevens as having argued for that. Justice Scalia's just read the dictionary approach, I agree. You can't use the 1954 Webster's Dictionary definition of waters, but in a more nuanced way. In isolation from all those multiple nested uses of water and waters and water bodies in the statute, relying on a definition of a single term in the context of all those terms doesn't make sense. But my further critique is that by using that term in the way Justice Scalia did, he took an entirely hydrologic approach. Are these continuously flowing surface waters? Do they contribute to the flow of navigable waters? Thereby ignoring important parts of the statutory text, which are the parts of the statutory text that talk about ecological protection and referring to waters as water bodies as in aquatic ecosystems. So if you're going to be a textualist, fine, but pay attention to all the words of the statute and not just to some of them. The Rehnquist statutory text and constitutional avoidance text How am I doing in time, by the way? Oh, I'm already over, I'm sorry. Okay, so I'll finish really quickly here, sorry. Number one, he made a move here, which I think is not talked about enough. It's one thing to say that Congress left the word navigable in the statute, but then he alludes to the navigable in fact test and not to the Commerce Clause test in U.S. versus Appalachian Electric Power. So it is possible to give meaning to the word navigable, but to get a much broader interpretation of the statute than Chief Justice Rehnquist did. Justice Kennedy's significant nexus test, it is correct to link it to the overriding objective of the statute, chemical, physical, and biological integrity, but Congress used that word to apply to the nation's waters, not just to navigable waters. He also uses the narrower Daniel Ball test, which I think is incorrect. And the concept of significant is nowhere in the statute, right? It was made up first by Chief Justice Rehnquist and then by Justice Kennedy, seized upon it. So if we want to be a textualist, we shouldn't be adding words to the statute. If you talk to EPA scientists, and I talked to Lori Alexander, who's one of the EPA scientists, who did the synthesis report before the Obama rule, she said that word drove the scientists crazy because it's not a scientific term, right? Scientists characterize the nature and the magnitude of connectivity between water bodies, but significant is a value judgment term. It's not one that scientists use. So my closing comment is that judges should not make up the science. Lawyers should not make up the science. We should defer to the scientists. And that's a broader issue that I plan to write about because there are other parts of environmental law in which we've done that. So thank you.
Those are great comments. I'm glad I didn't invest a lot in PowerPoint because basically 2/3 of my paper was just presented, and that's terrific. So what I'll do is I'll sort of maybe jump a little bit to some of my distillation of key points and also what can be done in light of these problems that Professors Adler and Mendelson mentioned. And I'll start off by saying one thing that I've looked for, which is just a curious aspect, to try to understand any statute. Obviously, reading the statute is central, right? Everyone agrees with that. And for those who are not deeply into the world of statutory interpretation, some interesting literature that you should all be aware of is in the last few years, people have gone back to track what statutes look like in the U.S. Code, but then looked at the actually enacted statutes, that is the public law versions, and found often dramatic differences. That is, Congress, when it passes laws, structures them, numbers them, drafts them differently, sometimes even with different language. And then there's a whole professional staff in Congress that takes those enacted laws and decides what to put in the U.S. Code, sometimes burying whole provisions. So, for example, by the way, I should say the payoff of the Clean Water Act is almost nothing, but for other statutes, it's really quite significant. But what's interesting here is that very often it turns out for formalists in textualists, a key underpinning of textualism is you have to think about what is drafted, is presented, signed by the president, okay? And so therefore statutes have primacy, legislative history is secondary and illegitimate. Well, it turns out very often what people thought was legislative history has been put in the statute, in findings, provisions, or in the package presented. So there's an array. So for all of you who might get caught in high-stakes battles, you need to look at the public law and also look to see if there was anything else in the package presented, because there are instances they found where even legislative history reports are part of what was shipped to the White House. And so you actually have the argument that the legislative history is part of the enacted passage. Okay. All that said, apart from some renumbering and shifting around, the 72 Clean Water Act was enough of a framework establishing statute that it's not dramatically different in the Clean Water Act in the U.S. Code from what it was in 72 when presented. But there are some numbered provisions, And so before I tell you about my paper, reading through it, there are a few things that struck me. One is, if you read it as enacted, cover to cover, first, even more than my articles, sleep it's a terrific way to get a good night's sleep. But it's assuming you can get past that problem. Reading through it, it's so clear, it's so much clearer, I would say, when you read it in the sequence written and drafted as Congress put it together. It's just anti-pollution is everywhere, as are the integrity goals, repeated references to aquatic, fisheries, breeding, and wildlife, which I have to look up and see what wildlife meant at the time, because that is just all over the statute and is less aquatic in its descriptive kind of innate nature. But the idea that this statute is really focused at all on navigability in the sense, just discussed in the sense of navigable, in fact, with shipping being a goal, it's really just very clear as you read it end to end. It's anti-pollution legislation, and it just says it from beginning to end, and very focused on effects, okay? And then the other thing that jumps out, consistent with the points just made, is the other thing that leaps out is the statute is very clearly a strong delegation of policymaking authority to EPA and then slightly lesser to the Army Corps. That is, the provisions, including grant provisions, research provisions, funding provisions, educational provisions, operative provisions, effects provisions, pollution technology, it is laden with clearly maybe more than any statute I'm aware of, express delegations to expert agencies to make sense of the statute. So when you pull back and there's arguments about meaning, there's also these fundamental questions about who should be the decider, who should have primacy, and what's clear when you just look at the 72 Act is it is laden with this focus, anti-pollution, science effects, and strong repeated delegations right across the board to EPA primarily and to a lesser extent the Army Corps. And so then to go forward, so what is my paper about, or what will it be about? So I've become really interested in what I call the anti-regulatory arsenal. That is this array of moves that now are assembled collectively in mutually reinforcing ways to attack regulation. And it has been central to the revamping of waters of the U.S. battles, but also some of the key waters cases, especially the Swank case, which I will not review in depth, but also to a lesser extent Rapanos. They also have become foundational to this anti-regulatory arsenal. And so what I'll do with most of my remaining time is kind of talk about the roots of this anti-regulatory arsenal and especially the mutually reinforcing effects. I really think that the previous two talks said a lot of what I'm going to say, so I'm going to try to kind of just jump to the distillation. So first, in the area of waters, if you haven't gone back to read the Riverside Bayview Homes case, which is the Justice White opinion for a unanimous court in 85, 86, I can't remember which year it is. But it reflects a wholly different frame. That is, if you read that case, it's not just that it comes out allowing the Army Corps and EPA regulations to apply to adjacent wetlands, to navigable waters, but the entire framework is one that reflects a sort of partner mentality that the court should be trying to figure out how to make sense of the statute in partnership with the expert agency's judgments about protections. It refers to, in that case, there were constitutional arguments made and constitutional avoidance arguments made, as they have been made recently, but with focus on takings. And the court basically just swats them away and calls them spurious and just says, these don't make any sense. And then it goes forward and says, okay, so here are the questions, and it points out correctly, as scientists will tell you in the waters area, that waters aren't a continuum. There's hydrological cycles, there's expert judgments. You have to look at the nature of waters and decide where in the continuum to say land and water begin. And it goes through all this, and it's very sympathetic to what Congress was trying to do. It's thinking about the effects. It's deferential to the agencies. It acknowledges expert judgment, not of the court, but of the agencies, and that Congress chose them. All of that shifts. And so I think the most problematic case, not just for waters, but included in battles over climate, is the Swank case that you all alluded to. And I won't. The Swank case is the isolated waters that Nina gave us the excellent picture of, and much of that case's power hinges on this one long, illogical, and seemingly typo-ridden paragraph written by Justice Rehnquist. I say typo-ridden because it has several logic leaps that it's like, did I just miss something? And if you look at it in case books, at least when I first saw others' edited versions, I assumed that they had cut language out because there's missing logic. But no, it's just the way it's written. But importantly to that language is, here you have, just to be clear, you have what had been commercial gravel pits. Okay, just to be clear, this was a commercial operation created the gravel pits. Okay, then you had their extensive use by migratory birds, which is of vast significance, plus their statutory protections, and previous cases had said migratory birds and related activity are kind of laden with commerce, so that was part of the understanding. And the proposal was to create a new waste handling operation, also commercial. Okay, it's hard to figure out how there was any issue whatsoever about there being a problem with a commerce link to these waters. But what does the court say? It says, respondents argue that the migratory bird rule falls within Congress's power. They note, okay, that these activities supposedly substantially affect interstate commerce and that there's a natural interest in migratory birds. Arguments raise significant constitutional questions. For example, we, the court, would have to evaluate the precise object or activity that in the aggregate substantially affects interstate commerce. Okay, now we're waiting. So what do you, the Supreme Court, say? This is not clear. Okay, for all that they say this, they now argue, post litem modem, they focus that this is a municipal landfill, which is plainly commercial. Okay, and your resolution? But this is a far cry indeed from the Navigable. That's it. Okay, so just to be clear, that language, thank you, has created a big problem in West Virginia and climate, because if you look at it, it's not, there isn't a clear constitutional problem. So it's really just a waving of the hand at a possibility of a constitutional problem, and then it takes a turn and creates what Dean Manning at Harvard has called a clarity tax, expecting a clearer statement of intent to reach the waters, and says not clear enough. It ignores the fact that it's a defined term. It doesn't go to the definition, it goes to the term, and gives way to navigable. You put that package together, it is a powerful move in any statute, because any broad statute will have first, a national statute always overlaps with state law, always, okay? All national statutes have major effects. That's undoubtedly the case, okay? And then if you add especially pollution laws, they always will intersect and overlap with land use. That is, it's not just waters law. Land use law always overlaps with environmental laws. And so you work your way through it. If you can just wave your hand at a constitutional concern, demand greater clarity, and if you don't find it, cut back on federal power, it is extremely judge empowering. Okay? So what's been said here, I think importantly, is the shift analytically from Riverside, Bayview Homes to Swank, and then Rapanos, and now Sackett, is a move from Congress choosing to hand the power to expert agencies to choose, to a new framework which is extremely judge empowering, where judges are coming up with the key lines. And the Sackett, this new case the Supreme Court takes that was mentioned earlier, Jonathan alluded to, the Sackett case, it just says kind of what should the test be for how a wetland is a water, which either reflects a mistake by the court, since the issue of waters is far more than just wetland, or it's the belief that the court should be ready to step up and define it itself. And so it's quite consistent with what Swank and the others have mentioned Rapanos does, which is judges grabbing power. So the question then is, what do you do? So what can be done? Okay, so one possibility is Congress can draft more clearly. During times of partisan gridlock, that doesn't happen much and probably will not happen. But let me just distill the arsenal and just give you a few suggestions, both as lawyers, policymakers, and especially before agencies. So what do we have? So one aspect is anti-federal skewing in a number of ways, you see here. Also, not mentioned by any of this till now, when you look at the language, these more recent cases are filled with language of accusations of agency overreach. Okay? So there is a concern that agencies are abusing their powers, and that's very evident, especially if you look at Justice Scalia's Rapanos opinion, where he thinks he establishes by citing a few litigated cases over waters disputes, and then says that establishes overreach. Now, without going into courses in logic that surely are taught at Case Western, you can't prove that something is unsound if you look at cases where people are alleging things are unsound. Okay, that is, the denominator is wrong for that kind of proof. Very importantly, these cases downplay any actual evidence or any actual respect for actual science. Okay, that is, the Clean Water Act is filled with language about integrity, aquatic effects, wildlife, and the rest. But you look at Rapanos, thank you. You look at Rapanos, you look at Swank, and what you find is there's virtually no attention given to what programmatically the Clean Water Act achieves with its overall efforts. So it's a kind of what you have. It's not just the atomization of language. It is a focus on particular alleged instances of abuse and no attention to broader programmatic benefits. And that's really quite striking. I agree completely with Professor Mendelson about the textualism, and I won't go into that. That was going to be most of my paper. But but this idea, I think one way to think about it is the current mode in these cases, I call it microtextualism, is this tendency to really look at a word and decontextualize it. And for those looking for the best scholarship attacking this, Vic Nurse, spelled Norse, a colleague of mine, Kevin Tobia at Georgetown have also written about this. Bill Eskridge has a new piece talking about this need to contextualize language to make sense of it, and they're really quite powerful counters to this acontextual mode of reading. So I'm down to 0 minutes. So I'll just say, so what do you do? So a couple things which have been said, I'll just emphasize. So I think the most important thing is to take statute seriously. I think that especially a statute like the Clean Water Act, if you really emphasize its many, many provisions in their mutually reinforcing goals, but also their intertwined functioning. If you look at some of the Affordable Care Act decisions, the Supreme Court does have a majority that sometimes will look at how statutes work and give weight to that aggregate integrated functioning of statutes. And so if we look at the Clean Water Act through that lens, it's a strong counter to this acontextualizing microtextualist move. I think similarly, something that Dave Owen and others have written about, and I try to, many others here actually, all of us, and that is partly when it comes to federalism, similarly, federalism concerns should not be decontextualized. Statutes make particular choices, and the Constitution does not solely protect the states. It is, also as Professor Manning has written about, it both creates a powerful federal government and creates some areas of turf for the states. And if Congress chooses allocations within its power, the court should not re-skew them in some preferred direction. And then the last thing, which maybe in the Q&A, I hope we'll get into this. I think that there's a need to very directly take on the Supreme Court, however you can do it politely, which is in the following way. This is a very powerful and hungry court that is eager to remake things in its preferred modes and preferred direction. But judges don't know much, okay? That's not to say judges aren't smart, but judges just don't know, okay? There is no one on the Supreme Court who is an expert in hydrology and connectivity and waters. None of them are expert in technologies. None of them know really on the ground what happens around the country between regulated entities and state and local and federal regulators. Their knowledge is at most derivative before what's presented or comes to them through what agencies do. And so I think what really is important is people emphasize as much as you can what the actual evidence is, what the actual data is, counter tales of overreach and abuse with actual things like cost-benefit analyses that often really try to break down effects and try to show what the actual data shows and what the science shows. And for anyone who wants to see a brief that does this effectively, not in the Clean Water Act area, in the West Virginia case, the big climate case, the power companies surprised many people by arguing in favor of EPA's power to regulate greenhouse gases from power plants. But the reason was they were really afraid of the court embracing a view that would fundamentally disrupt the complex energy markets. And so their brief, and their oral argument even more, was saying, don't mess things up. You don't know. And that was the heart of their argument. You, justices, don't know what your language might do to a complex area of markets, and federal, state, local market, competitive markets, different energies, pollution streams, technology, all the rest. And they said, we're juggling a lot. Don't mess it up. And so I think that's, to the extent there's a counter, it would be before agencies, and then as well as before the courts, really emphasizing what actual science and data show as an effective counter to what may be anecdotal and frequently erroneous claims. So I have more, but I'll stop there, in part because just try to make it so we all say something different. So thank you.
Well, get your questions ready, but I want to actually start by saying there was a lot going on here. It seems like a lot of agreement, but I think that there's a conversation going on between the three of you, and I invite you to reply and respond to each other.
Okay. Well, this has been just a pleasure to participate on this panel with my distinguished co-panelists. I'm very intrigued by the different approaches that each of you take to statutes. Professor Buzbee, I think, would say we should look at the Clean Water Act and its overall thrust. It's an anti-pollution statute. We should look at how all the provisions function together and draw some inferences from that. And I think Professor Adler, I actually thought the slide on waters, and water bodies was just brilliant because it shows the kinds of terms that get used in a statute when you pay extraordinarily close attention to the language. But one question I have for my co-panelists is whether one implication of a presentation like that might be, rather than saying that we have to be extra careful in how we use these provisions, we could draw a different inference about how statutes are drafted that might point us in a different direction for interpretation. The different direction might be these word choices are not actually all that carefully thought out. I actually, for years, Professor Carole used to come and guest lecture in my classes. He's a senator from Michigan for many years and passed away in the last couple of years. And my students would ask him, so do you read the bills when you vote on them? And he would say, well, my colleagues consider me to be much more in the weeds than they are. Yes, I do sometimes read bills, but I could not possibly read them all and still get my work done. It would be like reading every piece of mail that arrived in my mailbox. So one question I have for my co-panelists is whether the inference ought to be, look, the wide variation in word choices just tells us that it's not that carefully thought out, and interpreters instead should be seeking to kind of smooth the operation of the statute rather than reading these distinctions as meaningful.
So that's a really good point, and one that I struggled with because, as I mentioned, I didn't have time to talk about the anomalies in the statute. But I'll just give you one example. If you read Section 304L, which is the toxic hotspots provision of the statute, there's this interspersing of navigable waters and other jurisdictional terms, and it's really hard to make any sense of that provision. And I think part of what's going on is that when Congress wrote the statute in 1972, it was pretty well integrated, as Bill talked about, but then you had congressional staff and members of Congress in 1977 and 1987, the major amendments, and then there were minor amendments in between, and since throwing in terms without thinking very carefully about them. So I think that's a problem, but the reason I struggle with it is that we do have canons of statutory construction in which we have to make the assumption that if different words are used in a statute, we need to give them different meaning, and that's why I said that we need to kind of do the best we can with that. But it's also why I think we need to pay attention to the text of the statute carefully, but in the context of the overall statutory purposes and structure, more importantly. I think we need to avoid, frankly, relying on too much legislative history given this debate. And the argument that I made in the Maui article I wrote was that you don't need to rely on legislative history to get to this result. But if you look at the legislative history, it supports it, it confirms it. So it's not an approach that relies primarily on legislative history, but one to confirm what the logic of the text and the statute means. So that's kind of my response to that.
So I agree with all of that again. I guess I'd say, I think your question goes a slightly different direction, which is thinking about both courts and agencies. So you do have right now, at least half of the federal judges and a majority of the Supreme Court shun legislative history. Okay, they also are wary of any arguments that are a purpose of argument, unless, and this is the important thing, unless anchored in text. Okay, and so, and the Clean Water Act is an example of a statute that has its goals and its text and its operations do all reconfirm each other. That is, this is clear, this is not a statute that has some vague goal. This is a statute that chooses exactly what the means are, different programs and ways to achieve them. And so my sense here is that I would probably focus, I think actually what Dean Adler, do you still like to be called Dean? Former Dean.
Bob.
But what he points out is that there are these different uses, and most of the statute, when I was reading through it, the different uses kind of make sense in context, so I think, I'm not sure they were mistakes. On the other hand, if you link them to the particular goals, I think what you find is they aren't terribly different in their goals, as stated. That is, there are different kinds of water and waters, but they always come back to this presumption against pollution, always come back to protecting aquatic ecosystems, reducing pollution, and you have this language. And so, and the fact that it's expressed, I think what lawyers, to be effective before agencies and courts need to do is to really weave these powerful statutory arguments, weaving things together in their mutually enforcing message. And I think they are quite uniform. So I'm not sure in the end operationally it's different, but I think it makes some sense.
So questions?
Yeah, thank you so much for this elucidating.
Thank you for the elucidating history on the interpretation of the Clean Water Act jurisdiction, first of all. But considering the evolution of the history, starting from a point of some deference principle being applied to seeing a more activist role of judges in Rapanos, and now we having SCOTUS that may be indicating that agency overreach will be seriously examined and possibly expanding the scope of the major questions doctrine. I'm wondering if you can briefly touch on Chevron's treatment in this evolution and what, if any, what role should it have in this statutory mayhem?
I'll go first, so I'll be quick, which is, so first, the current majority on the Supreme Court, I'm not sure, I think they've only cited Chevron in one of their decisions, and that the majority has joined. And so Chevron itself, while not being overruled and the court hasn't gone that route, it's heavy reliance on Chevron is not the way for people to win. And so people are arguing differently. However, what I think is important is that if in the area of waters of the U.S., when you get to issues of the effects of the functions of waters, the effects of pollution in certain waters, the rationale for protecting, that's not language. That tends to be the other side of deference, which is quite consistent in the administrative law world, which is when you're looking at assertions that rely on effects, that's reasoned decision-making review and deference. And so I think that what you see people doing is shifting the analysis to saying, our judgments are reasonable in light of what the statute says, but especially our finding about effects. So they're not just saying language power, they're saying language and here's what we find on the ground. And so I think that's the way people need to argue it. That said, the underpinning of Chevron, which was an agency delegated power, that is the heart of Chevron, but that's also been the heart of cases going back to the early 20th century. And so that should be central. And I actually think, I don't know about Justice Gorsuch, who I think would like, and Thomas, like they might like to have no administrative state at all. But so putting them to the side, I think the rest of them accept the idea that agencies are delegated important roles. And I think that that's also a pre-Chevron conception that lives on.
It was a really interesting and to me funny question because we had a faculty job talk this week, someone who's applying for a job at Utah who gave a talk about Chevron. And I heard it after I had completed this presentation and sent the slides in, and it dawned on me, Chevron has played a surprisingly little role in the Lotus cases, and I wonder why that is. I don't know if you have any comment on that, but you raised the question that I had on the airplane, and I was thinking, why is that? I need to go think about that more.
Was your question whether Chevron still has any application in this area?
I was curious about the past treatment and why they play such a little role, but also your views on if you have any conceptualization of how it could play, or if should it play.
Yeah, so I agree with the comments that have already been made. In some ways, the Clean Water Act is a best case for the application of the Chevron doctrine because the terms, although varied, are broad, right? There's not a list of oceans, rivers, streams, and the like that are to be regulated. Instead, we have these broad terms, even with slight variations. And each of them, of course, has their distinctive history. And that's a setting where we think of an expert agency as really having something to offer, both because of its scientific capabilities and because it functions within the executive branch, which can be expected to be responsive to people's policy preferences via presidential elections. That said, the environmental area generally and the regulatory state generally in recent years has been the target of great suspicion by especially the conservative members of the court. And I think Professor Buzbee alluded to this. I had the quote in my notes, but I was running short on time. In his Rapinos plurality, Justice Scalia says, look, the agency's acting like an enlightened despot in this case, right? That's clearly a motivating concern. And so I think the court, not just Justices Gorsuch and Thomas, I would include Alito in that group as well now, are very concerned with making sure that they check what they perceive as a potentially overreaching regulatory state. And that means a much more aggressive application of the statutory framework that they have, much more use of textualist methods, much more use of the major question doctrine to say, well, that's all well and good that the agency was given a very broad delegation of authority, but we have to hesitate that Congress really meant this much authority. So I think we're going to see a lot less role for Chevron and a lot greater role for the court in drawing boundaries on the administrative state.
Yes. We have to defer.
This is a question for Brother Adler, but any of the panelists certainly can address it. What happens if we assume, or the court assumes, that the AEP case represents an overly broad interpretation of Congress's power under Article 1, Section 8? What does that do to, do we just shrink the analysis accordingly, or do we bring something else to the table?
Yeah, and I hope you know that coming from Utah, the term Brother Adler has a particular... I don't know if you would think that or not. So, you know, of course there are constitutional limits, but the question is where the lines are and where they're drawn. And what I think has been missing in the context of the Clean Water Act debate is that there is nothing in this room which was likely manufactured and traded in interstate commerce, which wasn't made in some way with water, right? And the Supreme Court in Sporhase said that water is an article of interstate commerce. So we don't need to find a channel of commerce to regulate water, right? And Congress regulates pollution of groundwater in Superfund, and that's been upheld constitutionally, and in RCRA, and the Safe Drinking Water Act, and other statutes. So I think there's been this kind of shifting of the goalpost in the Clean Water Act, where to find constitutional authority, you need to find a navigable waterway and a link to a navigable waterway. That may be a question of statutory construction, but Chief Justice Rehnquist's argument was that we needed to take a different approach to statutory construction to avoid a constitutional limit, which was, I think, a phantom, right? Because the constitutional authority over water is much broader.
Else? In the middle, and then.
I guess this is for Professor Buzbee. You mentioned evidence, and I'm an engineer, so I'm interloping on this whole thing here, and it's fascinating. But one thing I wonder is what kind of evidence works. So we work for an agency here in Cleveland, the Northeast Ohio Regional Sewer District, and we are under a long-term control plan. Would the results of that control plan, for instance, and the interpretations that we had to make along the way that weren't argued about, they were just sort of our interpretations of things, would those constitute evidence that could be used potentially, not just wastewater, but other types of evidence like that?
I think, frankly, any actual evidence of the effects of what efforts are achieving or predicted to achieve are one of the most powerful counters to courts stepping in where they don't know. So it might be that, it might be evidence of what's happened under permits, it might be analysis, that is involved in federal rulemakings, but people present expert reports about what should be done, what the effects would be. EPA connectivity report post-Rapanos that tried to look at all the different kinds of river streams and waters and how they worked, and then use that to inform the judgment and the Obama regulation. That was an attempt to do kind of the same thing. It was an attempt to try to say, this is actual peer-reviewed science, the best science we can find. And they even did that as a notice and comment process of sorts. They said, this is our draft connectivity report. Have we missed anything? And they didn't finalize it until they confirmed that no one said, oh, you've missed something. And so any of that's a powerful counter, but it doesn't mean it will be respected. I mean, that to the extent the courts look at it just as a language game and they just affix on, say, a word in isolation, and then they say it's for the courts, they may just disregard it.
And one back. Erin. Yeah.
Thank you. Thank you for these wonderful presentations. So I have a question about, in the vein of managing ambiguities in statutes like the Clean Water Act. Certainly all of our problems would be solved if Congress and the agencies could just speak flawlessly and with no ambiguities. But since that's never been true in humankind, we rely on courts to help. And you've been talking about ambiguities in the meaning of central terms like waters. It's a fantastic presentation, Bob, about all the different terms. But I also wanted to ask you with regard to the waters of the United States question, there's so much ambiguity on like higher order interpretive questions like default rules and burden shifting. And if we're in the gray area, how, my question is going to be about what should our theory of judging be in terms of how judges should manage these questions of higher order ambiguity in terms of legal architecture and infrastructure default rules and so forth, and also how should advocates pitch their arguments. And to ground this in something concrete, I'll go to the Rapanos decision, where I'm so obsessed with this point that I wrote a paper about it a few years ago, so forgive me my weeds here, but it seems like the Kennedy opinion that Bob, you critiqued for the use of significant nexus as a non-scientific word, was nevertheless sort of the best effort of a layperson to try to get at what Justice Kennedy thought the agency was trying to get at in terms of how to accomplish the goals of the Clean Water Act through some delimiting means of which waterways are we going to count and which not, is in some respects the mirror image of the dissent's position, which was to say we're going to let the agency be the one that determines which of these waters accomplish the goals of the Clean Water Act. And they're mirror images in that they both had a way of opting out. Justice Kennedy said, we're going to assume no nexus unless the proponent shows it, and the dissent said, we're going to assume there's a nexus, but of course, if the opponent can show that there isn't, they can get out of it. And so it really became an exercise in burden shifting. Who had the burden of proof? And I thought that was a really interesting feature. And I thought that the Waters of the the Clean Water Rule that followed tried to kind of capitalize on that insight and specify that. But this may all be obsolete in the direction that we're headed, but I wondered if you could distill from this insight that it's not just about interpreting the meaning of words, but also interpreting how to handle ambiguous features at that kind of infrastructural level of legal architecture. Who has the burden? Which is the default rule? When do we trigger it? What insights could you offer us about that?
So first of all, I read that article. It was a great article and a great analysis. But I thought your article actually highlighted another perverse shift in Supreme Court jurisprudence that's along the anti-regulatory lines that Bill was talking about. And that's from shifting from an administrative law mode to a litigation mode, right? So the whole concept of who has the burden of proof, ignores the idea that when you delegate rulemaking authority to agencies, they get to interpret the statute and write a rule which is administratively efficient, right? And one of the really challenging things, I think, for EPA of this whole area of law is the notion that you have to have scientists on the ground, demonstrating what a significant nexus is on so many case-by-case, situations, and the agency does not have the resources to do that. Right, so when you shift from the administrative law framework to the litigation framework, you really hamstring the agency in doing its job. So I think that's a big problem.
To go completely geeky scholarly on this, there's a great article published in 2021 by Anya Bernstein, who's a professor at Buffalo, I think. Where she takes on legal corpus linguistics, which I'm familiar with. And this is this new move that you try to interpret disputed statutes by looking at all of the uses of the term in kind of usually more common parlance, and she's someone who actually knows linguistics. And so the reason I mentioned her piece is her answer to that is you always have to put language in the context of how it functions. Language never works by itself, and so her whole last section kind of gives a linguist distillation of what sound reading is in the statutory area, and it ends up, and I can't do justice to it because it's both trenchant and fun read and really much more sophisticated than I am in this area, but she basically says you look at the words, you look at the immediate structure, you look at what they're trying to achieve in the language, because language always has a purpose to it, it's always doing something, and only then do you make sense of it, and if you decontextualize it, what you tend to do is to go astray. And so my sense there is, in some sense, maybe there shouldn't be as big a difference, that is, whether agency or court, if you really try to be clear about how all the words fit together to do something, it might mean an agency in some settings has less power, but I think that's probably correct. And in other words, but it also will other times very much affirm power. And so, like in the Clean Water Act, I just look at it, for me, which I didn't get into, Section 404, the dredge and fill provision that's at issue in Sackett, explicitly refers to Section 403C that says, in figuring out what's protected under 404, you use rationales comparable to ocean protection, which then has a whole litany of environmentally protective goals that are to inform those judgments. And so that's an example. So I would never say you look at 404 and waters by itself. You have to look at 404 waters in light of what Congress said provides the criteria. That's 403C.
Do I have a minute you asked a great question with a lot of subparts, and I think my colleagues here on the panel have responded to a couple of parts of that. I want to just chime in on one last issue. You said, what should be the theory of judging and how should advocates approach these cases? And I think one of the things I'm taking away from this discussion and my own thinking about it is that courts should, in a perfect world, courts would downgrade canons and downgrade dictionaries, in part because they're contextual, in part because they have been coming up with new canons and applying them in unpredictable ways. I actually have some empirical work on the canon use in the first 10 years of the Roberts Court myself that suggests that they're not being consistently applied despite claims for that application. So do we have to make sense of the language that went through bicameralism presentment? Absolutely, but a better way of judging and more faithful to Congress would be a contextual approach that is sensitive to what Congress was actually trying to accomplish. And word meaning ought to be anchored in what Congress was doing rather than what the board of the American Heritage Dictionary thought was the right way to define the term. What about advocates? I think advocates right now are stuck in this world of dealing with the way courts have been working with language, which has been way too much attention to tiny inconsistencies across the U.S. Code, varying definitions and corpus linguistics. But I'm hoping we'll evolve towards what I hope will be a more nuanced approach to judging that is more sensitive to Congress's primary role in drafting the legislation.
So thank you to Professors Mendelson, Adler, and Buzbee. It's been a really fascinating discussion, and we will move on.